All right, let's get it. What do I want to share first? You already know I'm not a licensed attorney or tax expert. I do this for educational and informational purposes only. All right. If you think you need competent counsel, find you competent counsel because this is not it. All right. This is for educational and informational purposes only, and in the hopes that you can do something better, make better decisions. Look, I got 10 bands on my wrist. I got a couple hundred in my ear. I got over 10K in my mouth. I got over a carat of diamonds in my mouth. Then a $1,000 ring, $3,000 chains, because it's from Italy, I guess. You know, I got 300 on my eyes. This 300, these Versace, all authentic. Versace belt, $1,000 belt. Look, the reason why I'm saying these things, I got the Gucci slides, the Gucci slides I'm wearing. These are like 600. You know, I got socks that cost 600. The reason why I'm bringing this up is because you can put it in a trust. You can put it in a trust. All these things you can put in a trust. I understand, and create a separate trust. And then create bank accounts with a pair of glasses. As long as it has value. You can make it, and now it's considered an asset of the business. You know, I bought it off the business anyways. So listen, an express trust, learn about private trust and express trust, because I'm going to teach you about truly expressing a trust. I'm about to dive deep in right now where I'm at. And it's 12:36. All right? Some places it's 3:36. Now look, check this out in the United States. Now look, I'm going to break down trust and private trust. An express trust is created when the seller expresses an intention, either orally or in writing, to establish the trust and complies with the required formalities. An express trust is what people usually mean when they refer to a trust. Every trust consists of 4 distinct elements. An intention of the seller to create the trust, a res or subject matter, a trustee, and a beneficiary. Unless these elements are present, or court cannot enforce an arrangement as a trust. And when it says a res or subject matter, I'm saying like, so is this an irrevocable peer trust? This a ministry trust? This a management trust? This a charity trust? This a college education trust? There's different types of trust. You got to understand, once you create your main trust, you got to start to learn how to create sub-trusts, all right? And this is why I'm bringing about expressing it. Because what is it on the record? Whatever you express on the record, that's what it is. You implement your own law when you're operating under trust, but you need to understand that everything is already under a trust. Starting with your name, and then the number that they gave you at birth. And if you're new to me, you might not know about this, but if you've been following me for a while, you should know what I'm talking about. When I Google who owns the national debt, and when I scroll down and I find the one from TheBalance.com, I like how they break it down. Who owns the U.S. national debt and how much is owed? The biggest owner is not foreign entities, but U.S. taxpayers. The U.S. debt reached a new high of 28.1 trillion. Most headliners focus on how the United States owes China. What many people don't know is that the Social Security Trust Fund, also known as your retirement money, owns most of the national debt. The Social Security Trust Fund, and it breaks down who manages it. It's the U.S. Treasury and the Bureau of Public Debt. This debt held by the public. You don't know that you're operating under trust. You don't know how to create the right forms. The government pretty much is doing what you tell them to do, is because you haven't been trained properly to be a true trustee. You haven't been trained properly how to be the executor or the trustee or the beneficiary. There's different roles that you have to play. You haven't been trained properly. And this is what I'm going over today. I help do this. I have another business partner that also does this. This is what we do. This is why I go around and try to make it make sense for you. Every private trust consists of 4 distinct elements: an intention of the seller to create the trust, a res or subject matter, a trustee and a beneficiary. Unless these elements are present, court cannot enforce an arrangement as a trust. Once you have these trusts created properly, you can have the courts now enforce them. The intention: the seller must intend to impose enforceable duties on the trustee to deal with the property for the benefit of another. Intent can be demonstrated by words, conduct, or both. It is immaterial whether the word trust is used in the trust document. Sometimes, however, the words used by the seller are equivocal. I can't even say that word right now. Apologies. And there is doubt whether the seller intended to create the trust. If the seller uses words that express merely the desire to do something, such as the terms desire, wish, or hope, these words expressing the wish, may create a moral obligation, but they do not create a legal one. In this situation, the court will consider the entire document and the circumstances of the person who attempted to create the trust to determine whether a trust should be established. So that's intention. Now, the res of subject matter, and like I went over that, like patents, copyrights, trademarks, it's talking about stocks, bonds, deeds. Property must exist and be definite or definitely ascertainable at the time the trust is created and throughout its existence. What's the trust there to do? And I'm just touching that. That's just a little bit about private trust. Everything is a private trust, even your word. So when you express your word on the record, you're expressing the trust when you're saying certain things on the record. Now, I got a little presentation set up for you now. I don't know if I should go here next. I want you to know, I'm gonna give you great trustee training material. You're gonna get my Laying the Path book, Passing the Buck Volume 1 and 2. You're gonna get a lot of trust documents, but expressing the trust about what I'm gonna go over, also with an MP3 that I actually read it to you. And other ebooks, Express the Trust Under the Common Law, Natures of the Rights. And I'm going to show you the rules of the signature. And a copy of Expressing the Trust on the Record. How you can actually express the trust on the record. How people should really be doing this. Now, when you click here, I'm going to make sure you get access to all this. Here's all the trust info that you'll have. You'll have plenty of ebooks. Just go through it, start reading it, start anywhere. And we got so many different trusts. Check them all out. We got banking trusts, because when you can award a trust, awards and contracts, charitable remainder trust, bills of transfers, and then there's plenty to read. College education trust, management trust. Learn about holding trust, living trust, revocable and irrevocable, the peer contract trust, how to revoke a revocable trust. There's a lot. How the trust break down with the federal government. So much to read, so much to know. You really should start. I really should teach you about special deposits. That should be a class next, special deposits. Because that's what's going on with expressing the trust on the record. Now, the keys in expressing the trust. Creating, claiming, and moving titles through A4V, UCC, GSA, and IRS forms. The key is in expressing the trust. My administrative remedy focuses on that. All the colorable titles, colorable contracts hide the root, which is the trust. Everything is a trust because there is no money. There's no value available to be given as consideration, so a trust fills the void. You got to start learning this and understand what's going on. There's only credits, okay? So, say I have a cup. Title to that has to be on a piece of paper. To reach the real thing in private, we go through the public with the colorable title. Colorable, appearing to be true, valid, or right. The pleading did not state a colorable claim intended to deceive, counterfeit. First, we create the title, which is a representation of the cup put on paper, its description. Get that notarized. Then we register it in the public, and that makes it able to be seen in the public, but we hold it in the private. We claim it on the UCC1 and collateral box 4. Then we get a certified copy of that and also file a notice in the county and get a certified copy of that. We just registered that title in the public, and we have a notice in the county and get a certified copy of that. So we just registered that title in the public, and we have 2 witnesses so the public can see it. Now we can move it if we want to. If we want, we can move it to someone else. And that's real right there. Hold on, let me see. Somebody really called me. Y'all crazy, yo. Peace and love. Now, whoever is holding title has liability. So when you get a car title, that's holding liability. We move it via UCC3. We authenticate it before registration, usually done by a notary. All this is done through commerce. The IRS forms are for the private side, the GSA forms for the public side. It's just like a ledger sheet or a T. On the left, public liability must balance with the asset side on the right, the private side. That's banking, which we do accordingly to GAAP rules and FASB. Both sides must balance, or the bank has to float a bond to balance the account. That's when you get arrested. They put the charge on the public and liability side by registering with the U.S. Treasury. Hitting you with charge indictments, and unless you balance the account, they'll balance it for you. But if you can balance it yourself by creating a title, etc., you do banking every day, but you don't know it. Everything coming into your mailbox is coming under the UCC Article 3 Negotiable Instruments under 3-115, which is incomplete instruments. Looking for your signature to make it complete. Look at that section. It says they're going to make it complete by adding words and numbers. Words like paid to the order of and maybe $1 million, and they get your signature so they can turn it into a negotiable instrument or a check. Under 3-115, they're going to add other docs with that, such as security agreements. This is how negotiable instruments ties into all of this. What we're leading to is, for example, in a mortgage, we start out with a promissory note, which is really a title. They want your signature to gain access to your exemption account, which is the Social Security account or the Trustee Trust, the public liability, which is drawn against the foreign situs or situs trust. The birth certificate trust is the private assets. Again, accounts must balance, so the promissory note is just a decoy so they can grab your signature and add words and numbers to it. The key is, how did you give your signature? It is the rule of signatures and the rule of forms. And when you get these documents, you know what I'm saying, drop a donation for just $97. That's all it is. I'm going to break down the word of signatures for you, so check this out. You can go right here, expressing the trust, and you really need to understand the rule of signatures. I'm not going to go over them this morning. But rule of signatures right here. It breaks it down. The law. It's 2 pages, breaks it down. All cold facts. How was the beneficiary trust created? Breaks it down. Peace and love, peace and love. Got Geraldine in the chat. Now, the key is, how did you give your signature? It is the rule of signatures and the rule of forms that counts. You never want to give your unqualified signature in the public because it's going to be construed as a straw man that gives them accommodation signatures and right carte blanche and access to your account. So I always put all rights reserved. You can restrict your account so that you have access to the account. You can restrict your signature so that you can have access to the account. You want to sign before signature by grantor, by trustee, or by beneficiary, the three parties to a trust, or sign as authorized representative for AR. If you want to sign before, I always put ARR or AR, all rights reserved or authorized representative. You got to understand what's going on, all right? I call it AR the portal term because it portals into your UCC under UCC 3-402, where the AR is signing for the contract debtor-credit relationship because it also can apply to trust with a Form 56 appointment to the AR, who may function as a co-trustee. Special conditions for that authorized representative, because now with the appointment, he's under trust. He can operate as assistant to the trustee and can, not sure sounds like the AR, could also be the trustee's assistant as the payer of the bill by the private contract on the Form 56. Without it, it's under UCC 3-402. Authorized representative could be either debtor, creditor, context, or trust. The Social Security account trust is really a sub-trust. Say again, the Social Security account / trust is really a sub-trust. And by giving qualified signatures that tells them you know who you are. And if you're telling me it's not a trust, why are they calling it Social Security Trust Administration? You understand? By not expressing the trust, we drop the ball. They pick it up and construe it in their favor, with you liable for payments, with FRN as a 14th Amendment citizen liable for statutes and codes. If you express the trust, you can make payment with private credit. As you function, you're going to have to give a key restriction to correspond with the duty you're performing. That is going to be looked at and compared with what you're trying to accomplish in comparison to how you're signing. Unless the key fits in the door, the keys won't open the door. The key is the rule of signatures. It's the key to accessing the treasury. Unless the keys fits in the door, the keys won't open the door. The key is the rule of signatures. It's the key to accessing the treasure. Everything becomes an act of gifting under the trust. Everything becomes an act of gifting under the trust. Everything becomes an act of gifting under the trust. Trusts were put into place in 1933 with the taking of the gold. Every colorable contract is wrapping and hiding a trust on its core. And the gifting of the res, or the principle of the trust, forms the corpus of the trust. Your signature is your Your signature is your representation of the trust and of all your past, present, future labor, your assets. Your signature is the res, the value and the principle. Your signature is the res, the value and the principle. Your signature is your representation of the trust of all your past, present, and future labor. Black Law's Dictionary, 2 kinds of trust: express and implied. Trust, the right enforceably solely in equity in court to the beneficial enjoyment of property to which another person holds legal title. A property interest held by one person, grantee or trustee, at the request of the grantor or settler for the benefit of a third party, the beneficiary. Express trust, a trust created with the settler's express intent, expressing the trust voluntarily, usually declaring and writing an ordinary trust as opposed to a resulting trust or a constructive trust. Implied trust, which is involuntarily, also called constructive trust, like the Social Security account, the form through which the conscience of equity, the court finds expression against one who has obtained property by wrongdoing. When property has been acquired in such circumstances, the holder of the legal title may, in good conscience, retain the beneficial interest and title, equitably converts him into a trustee. They deem us to be holding title illegally, and they convert us into the trustee. It is sometimes said that when there are sufficient grounds for imposing a constructive trust, the court construes a trust. It implies a trust because we did not express a trust first. The expression constructive trust is absurd because constructive is derived from construe, not construct. The court construes the circumstances. It explains them. It does not construct them. Now, the Trustee K trust is an implied or constructive trust with the Social Security. That is a Social Security trust. It's also a Trustee K trust. It is a beneficiary of the Foreign Citizen Trust because you did not express the trust after age 18. The Trustee K trust is the remedy by which the courts finds justice for the one who has lost his property to one who does not legally have a right to the property. They construe the trust with you as the trustee. You were supposed to pay, you didn't, so you are in breach of fiduciary duty. You can go to jail. You should express the trust with your intent under, say, 1776 law form, which is pre-United States and pre-statutes and codes, so you could then pay with private credit or negotiable debt instruments or NDIs, and you would be safe in making private payments with private credit. They put you under public policy where you have to pay with Federal Reserve notes. If you would like to make payments with private credit, you can always correct the problem. Under the Restatement of Laws on Trust, 2nd edition, at page 332, it says power of revocation or modification. Admitted by mistake, the settler can reform or modify the trust to reflect his original intent, even when the court construes the trust to be irrevocable. I'm going to state this again. Under the Restatement of Laws on Trust, 2nd edition, at page 332, it says, power of revocation or modification admitted by mistake, the settler can reform or modify the trust to reflect his original intent, even when the court construes the trust to be irrevocable. Because you did not express it being revocable or modifiable, you did not know that you as a settler had such powers. A practical example, a mortgage foreclosure case where foreclosure sale was set before any documents had been filed and documents were prepared that expressed the trust in 3 lines and a footnote and case cites. The court construed the trust and appointed the trustee as defendant. Our notice of interest, a statement that we are expressing the trust, alleged that the defendant was the beneficiary now, not the trustee as the court had construed. The sale was postponed 2 hours before it was set to go. Excuse me, let me clear my throat. All right. We determined that the reasons for the postponement were: anytime the trustee and the beneficiary are one and the same, the trust freezes or terminates. Anytime the trustee and the beneficiary are one and the same, the trust freezes or terminates. The court construed or implied the trustee to be the defendant, where we came in and expressed the trustee to be the beneficiary of freezing the trust. More importantly, we filed the statement of interest, and it has to be filed within 30 days of claiming the NOI, because the NOI times out. This gives the court notice of a claim, so it could not give free and clear title with a notice of adverse claim. The statement of intent supports the fact that we are the grantor and the beneficiary. That case collapsed, disappeared. The statement of interest is confidential commercial information, and it can get IRS enforcement. Now they can't construe the trust. When you're under trust, you're not under debtor, creditor, or agency, or statutes and codes, or the 14th Amendment citizenship status. You are under private law. Courts can operate in both the public and the private realms. They got you in the trust, but believing that you're operating under the debtor-creditor. The 3 parties to a trust is the grantor, the trustee, and beneficiary. They do not have to have knowledge that they are forming a trust relationship that can be seen and recognized by law. That's how they trick you in court. You're not qualifying your signature. You give them access to the account by accommodation rights based on the birth certificate, the SS5 Social Security application, and the IRS 1040 form tax return for individuals. A contract that gets you under 14th Amendment debtor-slave citizen. Besides authorized representative, another word that has 2 functions is transfer. Under UCC is 3-200s, where transfer is really negotiation of a negotiable instrument by assignment, endorsements, delivery by bearer, or by operation of law. Transfer also means under trust law, one of the means of forming a trust. We qualified our signatures as grantor and beneficiaries and appointed the judge as trustee for closure and settlement. Look up definitions of special deposit, trust deposit, and trust receipt. I'm going to say this again. Look up definitions of special deposit, and trust receipt. Trust receipt is a pre-UCC security device now governed by Article 9 of the Code, consisting of a receipt stating that the wholesaler or buyer has possession of the goods for the benefit of the financer. Today, there must usually be a security agreement coupled with a filed financing statement, UCC-1, with the security agreement on it, just like in a mortgage case. This is a trust receipt if you express the trust first. And a receipt is a record of payment. If you didn't express the trust, they construed it to be your UCC filing under debtor creditor law, and now you owe a debt. If you had come in expressing the trust, that UCC-1 filing with the security agreement would be a trust receipt, a record of the payment being made. The key is in the expression of the trust. From the Treasury Department website, Federal Reserve notes are not redeemable in gold, silver, or any other commodity and receive no backing by anything. This has been the case since 1933. The notes have no value for themselves but for what they will buy. In another sense, because they are legal tender, Federal Reserve notes are backed by all the goods and services in the economy. I hope that all made sense. I'm going to go over something else, Linky, but I want to show you the actual trust I got and how to express this. So I'm going to make sure y'all get this right here. This is part of the package. $97 donation to the Cash App. The Cash App is TheDonKilam, TheDonKilam. Put hashtag EXPTrust in your email address in the memo box. And I'll make sure you get access to all this information. So look, when you express this trust, you can do this for court cases, anything. If you didn't hurt nobody, if there's no real victim, okay, it's not a real crime, all right? The commercial. Expressing the trust, you're making a special deposit, a bill of claim and equity, presentment to void proceedings and jurisdiction. You have to express the trust on the record when doing anything. The principal and beneficial, equitable title holder, you have to express it because nobody else can take in these claims. They make the corporations that you're dealing with the beneficiary, all right? They become beneficiaries. You're signing over power to them. They're becoming beneficiaries. You're becoming trustees. This is 35 pages of how to express your trust. If you're in a jam, however you want to do it. 35 pages. Breaks it all down, how to express your trust on the record when dealing with any matter, whether it's property, whether, everything is property on the record anyways, even if they're talking about yourself. So I just want to show you that. The matters of the public for the interest of, be yourself, and then it would be the trust. All right? How to express the trust properly. And then I got plenty of ebooks to go along with this. Now, I'm going to close this out. How to activate a trust, all right? How to activate a trust. A pure contract trust will not become a meaningful instrument for you, nor will it protect you and preserve your assets until you accomplish the following steps. These steps should be accomplished as soon as possible after you receive your documents. The pure contract trust has been very carefully designed to provide the managing directors through the minutes of the trust. It has the directions in it. The power to manage and enjoy the assets of the trust. Since this is a do-it-yourself document, you must with diligence accomplish some very necessary procedures in order to protect your privacy. You're going to establish a new identity insofar as any official records are concerned. You may no longer hold title to any real personal property, bank accounts, IRAs, annuities, or any other type of accounts which are public records. You can even put your Bitcoin in them. I promise you. Having purchased the use of a pure contract trust, you're created a sovereign individual entity that operates according to Hale versus Hinkle. Now you have to make some further strategic decisions. Do you personally want to operate as a sovereign individual or as a person subject to statutory jurisdiction? If you receive Social Security payments, pension checks, Medicare benefits, etc., you may want to continue operating as a person subject to statutory jurisdictions. If you decide to change your status to sovereign individual, then you need to choose between two major approaches for doing this. You go the whole hog and rescind your birth certificate, social security number, driver's license, car registration, etc. You use the affidavit of truth to declare your sovereignty while retaining your social security number. Which assets and activities will be owned and performed by you personally, and which by the pure contract trust. I like to operate with the social, but the trust is it's in the Schedule A. You put the contracts in the Schedule A. Because the birth certificate is a contract, the social security card is a contract, your license is a contract, so you make the trust the beneficial owner of all these contracts. You know? But I want you to learn how to be a trustee and learn how to do the meetings and record what's going on, because in the record keeping is where if they ever want to look into it, you got records of everything you buy, everything that's in the trust. You had meetings first, and then y'all decided to buy it, and you get the bill of sale. These are important bookkeeping steps. I always use a personal, I post a one, virtual addresses, all right? For extreme privacy and security, you could organize your affairs so no banks, utility companies, credit bureaus, or government agencies know your physical address. To organize this, utility accounts need to be opened in names other than yours, the trust. Appoint certificate holders. Name the successor, the managing directors. If you got directors. Figure out which bank you want to deal with to exchange your assets. Schedule B is going to be exchanging real property. And then decide how to handle your vehicles. Change all your vehicle insurance coverage into the name of a trust. Place mechanic liens on the vehicles. Whether they're owned free or clear or not, make sure that the trust or your holding company places liens on your vehicles. Change the name of the owner of any investments you have to the name of the trust. Transfer the details of your will into the trust minutes. Put the details of your will in the trust minutes. I'm dropping you a valuable game. If you find this information valuable, make sure you leave a donation at donkilam.com/donate. donkilam.com/donate, or drop a donation on the Cash App. That's TheDonKilam. 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 Trustee. How to actually execute the will in a low-profile way. I'm going to break this down because I've just had a question about this. To avoid undue intrusions into your financial affairs, you could use one of the widely available do-it-yourself will kits. All right? Follow the instruction for witnesses. Now, if you must use a lawyer, mention only the assets you intentionally are not placing into any trust. They are in fact the assets which will be part of your estate. If the lawyer asks about other property he or she thought you might have once had, simply say those assets no longer belong to you. Breaks down about wills, man. Banking, how you handle your banking transactions. Breaks down the Supreme Court case. Trust recording number. These are all things you need to know. The Social Security number. Commingling funds. How to open bank accounts. One of the first steps of financial privacy is keeping your bank account confidential. Appreciate the donation. Appreciate the donation. To Geraldine, appreciate the donation. She up with me early on the East Coast. So one of the first steps to private financials is keeping your bank account confidential. Banking services, checking and saving accounts as well as loans seem almost indispensable in today's highly mobile society. A checking account offers a convenient way of keeping track of income and expenses. permits you to pay for goods and services in person or by mail, and it's a relatively safe place to keep idle money until the U.S. collapses. Unfortunately, your bank account is also vulnerable to official government snooping. This is especially true since the passage of the Bank Secrecy Act of 1970. For complete privacy, eliminate any and all personal bank accounts. A separate bank checking account may be opened and maintained for each trust, but is not necessarily. This will afford the same access to funds, but will give privacy. To open bank accounts for trusts, you must have to become more resourceful and visit several banks. If you persist learning more as you go, you eventually succeed. Sometimes this is great learning experience on how to better apply for the power message principle. I like Chase and Bank of America, but credit unions are also great. It would be better to select a bank where the managing directors are not personally known. The social security number of the managing director may be on file, and a bank clerk may incorrectly connect the trust with the social security number of the managing director. There should be no reason for you to have to divulge your social security number. You're not responsible for the debts of the trust as the managing director. You may want to interview the new accounts representative of the bank before opening an account. Walk into the bank with a friendly attitude and request information from the new account representative as what they require for opening a non-interest bearing account. The typical opening amount is $100. With Chase Bank, you don't even have to fund it right away. You got 30 days. Certain questions will likely be asked, such as personal account or a business account, since the trust name sounds like a business account and the bank representative must put it into one of the two categories. The likely answer may be that it is in the business category. Another question might be, is this your trust? The answer is no, I'm the managing director. Unless it's absolutely necessary, you never say to a government bureaucrat that you're the managing director. Ask the bank representative for a copy of the signature card and the usual accompanying information booklet about deposit accounts so that they can be taken and read. Certain statements on the signature card should be read carefully so the managing directors are aware of what they would certify by signing on the penalty of perjury. Be fully aware of the contract entered into when a bank account is opened. The bank may or may not allow the signature card to be released without first opening an account. Later call and make an appointment with the new account representative you interviewed to actually open the account. If documentation of the trust is requested, provide copies only of 4 pages of the trust. These pages are the cover page showing the recording, signature page showing signatures and notary of signatures, page 3 of the minutes showing the appointments as managing director with the authority to open and maintain bank accounts, and then an agreement and contract showing the signatures of trustees and the managing director. Now, the bank may, excuse me, the bank may also ask for minutes instructing the managing directors to open the account. If so, you simply draw up the minutes and present them. Another possibility is to set up a Wyoming trust with a name different from that of the peer contract trust. Once the account is open, you tell the bank that the business is expanding and where you're opening a division called whatever the trust is. In some states, they don't even ask for formal DBA doing business as proof. You can then deposit checks made out to the name of that trust in a Wyoming trust account. You stamp the back of the checks and DBA them. I do Nevada. Another way to open an account is to ask for the requirements to open a non-interest bearing account for a sole proprietorship. You should, of course, do only what's lawful. When asked for an identification number, you might say, oh, you mean the government number? And when they say yes, read out the county recording number, which is in fact a 9-digit government identification number. Have the number written on a separate piece of paper and refer to it. It's perfectly lawful to do this as is a government recording number. However, the bank representative may not be familiar with this type of number being read as an identification number, and if the bank clerk says the computer will not take it, request that they override it because it's a government 9-digit ID number. If this does not work, take your business elsewhere. You could also say our legal department has given us a directive. Now, if you purchase this information and you don't have my W8 bin class, I can show you how to open certain things up without the social with the W8 bin. I'll include it as well. Just let me know. If there is to be more than one signature on an account, request that the card be taken so that the additional signatures may be signed. It goes on and on. It'll teach you how to open up bank accounts. With the trust. Breaks down how to exchange property. The kinds of properties that can be held in a trust. A trust may own any property, real or personal, legal or equitable, which is in existence and which has value. But we always feel record the deed by taking it to the office of the county clerk, county recorder, or whatever office records property transfers in the county. There will be a minimum filing fee. You always file stuff with the county clerk. Some offices of the county recorder may require an affidavit of property value form or something similar to be filled out. The reason is that the assessors use the data to develop tables and schedules for the uniform valuation of properties based on fair market value. This form typically allows for an exemption to the affidavit of value. If there is no lien on a vehicle, take the title and registration to the motor vehicle department and request that it be re-registered into the name of the trust. Typically, the cost of this is minimum. You can also create your own title. Record it with the county deeds office. Life insurance is one type of property that you can put in a trust, transferring stocks, bonds, real property. That's what I got for you guys tonight, man. Much peace and love. Expressing the trust to bypass probate. All right. Includes over 75 ebooks and template guides. Cash App $97 to TheDonKilam. I'm coming to a city near you, man. My next event open to the public in Las Vegas. Go to MalikKilam.com now. If you want to see the big business conference, November 5th and 6th, Phoenix, Arizona, go to A2B Business Estates. That's ATOZ businessestates.com. We got the nationality tribal IDs. We got the plates in the background, private trust property. Teaching y'all the game, man. Learn the truth, man. Prosperity is your birthright. But look, check it out, man. There's so much more we can go over. Like, I do private trustee classes to let y'all know what's going on. I'm letting y'all know certain things to read, but I'm going to give you all of this. All of this. Look at all these files. Some of you already got some of this. But I want y'all to have all the trust files. I want y'all to have all the trust files. How to create your own trust. How to do record keeping, bookkeeping, keeping minutes. Learn about the ministry trust. Learn about different trusts. We got college education trust. We got manager trust. Teach you how to do the UCC1 properly and build business credit. The charity trust. Common law trust. Ebooks. Family trust. The master file. You ain't even ready for the master file. Let me show you the master file real quick. What secrets the IRS file subjects you to anything the IRS wants to do? And how can you change all of that? All with the trust. The peer contract trust. But you got to learn how to express the trust and create your special deposits. Your private special deposits. Everything is commercial. Everything's under the trust. Everything's about full faith and credit. That's what everything's about. So you got to learn the game. You got to learn that your name's a business. You got to learn how to operate correctly. When you talk about status, it's which position are you in? Because when you figure out which position that you're in, whether you're a grantor, a beneficiary, or administrator, whatever it may be, a CEO, a manager, or a member, a president, or a vice president, whatever it may be, these are different statuses, and this is what's going to show you have rights for. I got this 35 pages right here. Expressing the trust, special deposit, bill, complaint, equity, presentment to avoid proceedings and jurisdiction. You can use this for pretty much anything. And then you got to learn how to assess the tax and express the trust correctly. And when I say express the tax, assess the tax, you got to understand. Under 28 USC, these are actual codes now. 3002. 28 USC 3002. If you look at court, because everything's going to go to court at the end of the day if there's always a controversy. Court means any court created by the Congress of the United States, excluding the United States Tax Court. So if the issue was not brought up by Congress, then it's going to be a tax issue. And you got to understand that when you're looking at who owns the U.S. national debt. And what is debt? Debt is amount that's owed to the United States to them. So if you owe any debt, that's a debt owed to the United States. You got to understand you are the creditor. Never say you're a person. Security agreement, an agreement that provides or creates for a lien. Create your own security agreements. United States means a federal corporation. Everything's a tax issue. With that, I'm out. Much peace and love. Make sure you get the donate and get the ebook, $97. TheDonKilam on the Cash App, hashtag EXP Trust. And your email address. Much peace and love. Remember, prosperity is your birthright. I'll catch in with y'all later, man. I'm booked. I got a lot of work to do. I'm catching up on paperwork, but I am coming to a city near you, man. Also, I will be in Seattle, Washington, August 16th. So I'll make sure you drop a donation. I'll meet private meetings, $100. I'll pull up and see you, man. Peace. Peace and love. Peace and love. Peace and love. Oh, world.
Goodbye.